Should corruption charges need prior sanction? This question came up before the division bench of the Supreme Court that delivered a split verdict on the constitutionality of Section 17A of the Prevention of Corruption Act 1988, a provision that requires prior governmental approval before investigating corruption allegations against public servants when such offences relate to official recommendations or decisions made in the discharge of their duties. So, this provision mandates that no police officer shall conduct any inquiry or investigation into any offence which is alleged to have been committed by a public servant under the Act, unless the police have obtained previous approval from specific authorities. So, on the one hand, Justice Vishwanathan held that Section 17A is constitutionally valid only if the prior approval mechanism is filtered through an independent screening body, specifically the Lokpal at the central level or the Lokayukta at the state level, whose recommendation must be treated as binding on the government. So, Justice Vishwanathan recognized the crucial role that civil servants play in the functioning of democratic governance and the genuine threat that frivolous or vexatious complaints pose to effective administration. On the other hand, Justice Nagarathna held that Section 17A is like an old wine in a new bottle and is unconstitutional. She held that under Constitution's Article 14, which deals with the right to equality, requires intelligible differentia and rational nexus to the legislative object, and that Section 17A fails on both counts. She held that adequate protection for honest officers in the form of prior sanction from the government before prosecution by a court is already available under Section 19 of the Prevention of Corruption Act. Now, this matter will be heard by a larger bench of the Supreme Court for a conclusive decision.